even on the basis of the law, what the defense is asking you to do is not to reject these charges because they do not disclose the particulars. Because the particulars are here in English. They are in bold and they are italicized. What they are saying is they doubt whether or not these particulars prove the offense under section 94(1). Now, under Article 157(6)(a), and again, this constitution can only be exercised in terms of the Constitution. The Director of Public Prosecutions has powers to institute criminal proceedings against anyone, including the suspect, for any offense, including Section 94, alleged to have been committed before any court, including this. So that it is not for the defense to tell us that this offense is fit for bar brawls and drunkards. That's actually funny again, Your Honor. I saw you laugh. It's actually funny. The person who determines whether it is a drunkard should be charged with this offense and not this one is constitutionally vested with the Director of Public Prosecution, currently Mr. Renson Ngonga. So if that is correct, if they are unhappy with this offense, they can propose a better offense which fits, the stature of the suspect. But for now, we want to charge the suspect. In fact, Mr. Watuta wonders why we're charging their client with an offense for 5,000. We are willing to charge her with another one for 1 million, if they recommend. But for now, we are charging her with one where the fine is 5,000. That's actually a constitutional argument. Your Honor, as I conclude, I am going back to Article 24 of the Constitution vis-a-vis Article 33 of the Constitution. The third argument by the defense is that if you allow these charges to stand, then the plea will be unconstitutional. This is the first time I've heard that a plea can be unconstitutional. But in constitutional law, we have had a lot of things. It is admitted by both sides that rights outside Article 25 can be limited in an open and democratic society. It is not denied that Kenya is an open and democratic society. Then Article 33 gives the right it will be reminded by my colleague. Of Article 33, 1 and 2. So that, Your Honor, all this discussion culminates back to Section 134 of the Criminal Procedure Code. That all that is required of the prosecution is to have a statement of the offense. We have that. To have the particulars of the alleged offense, we have the allegations here which we are saying the suspect said. There is no requirement under Section 134 that the quality must get to certain level. It should just be sufficient to understand. And they understand. The only disagreement is that it does not disclose threatening, abusive, or the part. If you find for us that, in fact, we have met the provisions of Section 134 of the Criminal Procedure Code, then the defense, because we will meet with them, and I'm sure they are experts in this area, must be stopped from this practice of forcing us towards mini trials instead of taking a plea. We urge you that the best approach should be that plea should be taken, and then witnesses should be cross-examined. Then the court makes a determination whether or not the elements have been proved at Section 210 acquits, or discharges or acquits, and at Section 215 acquits. This matter is not right. The application is not right as we speak. In conclusion, Your Honor, if the defense think that there has been an alleged violation of rights of the suspect outside Article 25, this building also hosts the High Court of Kenya in terms of Article 165 of the Constitution. They know the proper pleading and the proper forum. Allow me to finish on a good note. We were not going to oppose bail if plea was taken, number one. And we agree with the arguments of counsel that this offense is a misdemeanor, and I salute you, sir, because that came out towards the end, that because it's a misdemeanor, it would be illegal to hold the suspect pending other motions. We would, however, require that, request the court that you require that there is some personal cognizance or whatever form for her release. We thank you, unless there's a question.
So, on the flip side,
yes.
If it's about speculation, I believe what they are really doing is right. And so the DPP has a right for it.
Yes, that's correct. And that's what 135 says, now that you brought it, Your Honor. That if the court finds that we have not met the test in 134, then you go to 135.
I wanted to say that because I want to give them an opportunity
yes.
to address that issue.
Yes, that's right.
Thank you.
I'm most obliged.
Any other on your end? You are done.
My people say that I carry the donkey. I hope I've done them.
I will briefly respond to the issues raised by my learned friend, then I'll invite Mr. Kirango and the chairman to address it briefly. There is no misconception that, but I want to begin that nilimwacha aongee in talking. Your Honor, you have been told that Section 94, subsection 1, is what counsel is defining as normative. That's a misconception. That provision does not qualify to be defined by that doctrine. The simple reading of the word normative means it relates to a norm, a rule, or a thing that should be. So if you were to argue, therefore, that Section 94, subsection 1, is to be constituted or to be construed as a normative derivative vis-a-vis the provision of Article 33, the question therefore posed to the court, therefore, in determining the norm in Section 93 would be, in normal circumstances, how would court regard such a statement captioned by the charge sheet? What norm is arising or accruing from the particulars of that charge? And must that norm conform to the provision of Section 7 of the 6th schedule? Again, simple reading of derivative means which can refer to something that is derived or taken from something else. It's about, that's able to say, Section 94, subsection 1. If you were to juxtapose it to the normative derivative doctrine, vis-a-vis cannot then be said to have accrued or the provision of, and that is why, of course, deliberately so, because he does not the fact that Section 7 of the 6th was enacted so that it can assist the court where an amendment has not been initiated by the relevant authority. I concede it's only Parliament that can legislate. Yes, that I concede. But in the absence of a legislation, what is the import of Section 7 of the 6th schedule? And what is the scope of the application of Section 7 of the 6th schedule? If the scope is not such, the scope of application is not such as this one. The reason why the reason why the people of Kenya enacted Section 7 of the 6th schedule, they were alive to the fact that not all laws that may suffer amendments or repeals upon the enactment of the new constitution. And therefore, they created an avenue for a magistrate or a judge to have the flexibility of dealing with a situation as and when it arises. Of course, my learned friend would want to argue, on the contrary, that it calls you, it limits you and makes you rigid to the interpretation. That is not the expectation. He has addressed you on the question of the repeal. If, even when a repeal has not accrued of a section that is not in conformity with the Constitution, the obligation of the court faced with such a challenge is to make sure that that section does not defeat the purpose for which the Constitution was enacted. And then where do you get that purpose? You get that purpose under Article 10. The benefit of my learned friend, who seldom practices constitutional law, Article 10 says, the national values and principles of governance in this article binds all state organs, state officers, public officers, and all persons whenever any of them applies or interprets the Constitution. That is not what we're inviting you to. Enacts, applies or interprets the law. That is what we're inviting you to. This law, Section 19, Section 94, subsection 1. And at this juncture, Your Honor, you might want to seek the aid of the interpretation, the tools of statutory interpretation. And one of the tools I suggest that you apply in these circumstances is the golden rule.
Sorry, Your Honor, I hope we are not opening new areas of arguments because ours is closed. So counsel should just stick to what came up and the law so that we are not able to require to.
He addressed you on the applicability of Article 10, Your Honor.
Yeah.
And I have simply dealing with the question of Article 10. I invite you to apply the tool of the golden rule. In 1930, when this section was being enacted, what was most relevant was the mischief rule that Parliament, as at that time, wanted to address. And this case is a Parliament granted that this country was as at then, and Her Majesty government wanted to guard, control, and subjugate the people of Kenya. Okay, I'll elaborate on that, but I know I could have not. Now that we have the new constitution, so that you may not resort into the absurdity that the DPP is inviting you to, must apply the tool that enhances the enjoyment of a right other than limit. And that you're being invited by Article 19, 20, and 21. To argue that Section 8 of the Magistrate Code limits you, again, would be to miss the point. There's no possibility that the Constitution can give you under Article 10, which provides, again about these values, and I want to just mention the value of human rights. That when seated there, Your Honor, you are bound by the values of human rights. And where do you get these values from? The Bill of Rights. So are you then supposed to apply the Bill of Rights selectively, exclusively, and in a limited manner? If you're then being invited that the only jurisdiction is under Section 8, subsection 2, then how are those rights contemplated? They are capable of being denied, violated, threatened, or infringed. By the deliberate use of the word threat in the section, threat, violation, denial, or infringement invites you to holistically analyze the entire concept of human rights. It does therefore not limit you under Section 8, subsection 2. Otherwise, how can the Constitution give you and then a legislation take? Again, you must interpret it in a manner that advances the enjoyment of that right other than limiting it. Again, that is again on the doctrine of the law, that you expound the law in a manner that facilitates the achievement of that objective. I will again address you on Article 50, Clause 2. And this, I'll leave it at this and then invite Mr. Kirago. Because this article, Your Honor, tells you that when a subject such as honorable member is brought before you, must be informed of the charges with sufficient details to answer. So the DPP does not just have the liberty of crafting anything and anything goes. That as long as you are here, the only obligation is to answer.
Your Honor, this argument was made by counsel when they were making their argument. What we understand, let me finish, sir. Let us just have courtesy. What we understand as response, just sit, I'm finishing and then you. Yeah.
You note that they don't have a place to sit.
No, you, it's okay. He has a place. So we are pleading with them. We are pleading in response so that we don't regurgitate. We just issues that have arisen.
Okay,
legal issues.
I'll abandon that argument. I'll take that objection. So that you. Yes. No. There is no judicial overage because if I was to read, and again for the benefit of my learned friend who seldom refers to it.
So sorry, this second time I'm not taking it. I am not. I am an advanced master's holder in constitutional law. It's not. Should not throw the shades.
It's one thing to hold a master's, and yes, and we are not surprised by those credentials, but surprised by the inability to apply the same.
Now this is causing us damage here. I am not the kind of person to be intimidated by people like Mr. Adequacy. So this court should just direct him that he respects the court if he doesn't want to respect me, and if he doesn't want me to lose my respect for him today. Because I take my education seriously, having listened from Islam, that I can't allow someone else to make shapes. So please. Please, just respect me. Yeah. Yeah.
Well, guided. Yes, yeah. Yes, Your Honor. There is no judicial overreach, because the philosophy behind the enactment of Section 7 was in the mind of the drafters of the Constitution that there exist laws and there was need and the necessity to save those laws so that they may not all be considered to be inconsistent with the Constitution by virtue of Article 2 of the Constitution. And that is why, Your Honor, Section 7 says all laws in force immediately before the effective date continues in force and shall be construed with the alteration, adaptation, qualification, and exceptions necessary to bring it into conformity with this Constitution. So this is an invitation to any judicial officer who seeks to adjudicate over a dispute. Additionally, Your Honor, this is also in respect to any other state organ that is invited to apply laws. For example, the procurement laws that were enforced before then, or perhaps the marine laws that were enforced before then, or any other law. So there will be no judicial override, Your Honor, if you are then to apply, because that is a constitutional invitation that you cannot avoid. Most obliged.
I think the chairman has 2 sentences.
Just 2 minutes.
Your Honor, I don't know whether this would be an interruption of the proceedings.
Mr. Owiti has a habit of always rising when I rise. He can stand, I can submit when he's standing. I don't have a problem. But let me make my submission.
Your Honor, I was just going to make a small request. I am not your enemy, sir. I was going to make a request so that before they are done, we let them finish. I just want to mention an authority. I'm not arguing. Just bring it to your attention if you allow me to read a paragraph so that as he responds, they also tackle.
Your Honor, we are beyond that.
I am allowed to make an application to reopen. So
he has already closed his case.
Yes. Okay, that's fine.
Yes, that's the rule.
He cannot be allowed to be sitting.
No, I think the court has directed. The court has directed. The court has directed.
Yeah, Your Honor, very briefly. There is a suggestion that we are inviting you to a mini trial prior to plea. In many words, that's our point. We are not asking you to evaluate any evidence. We are only asking you to look at the content of the charge sheet in terms of the wording and look at the relevant section of the law that is said to be based and make a judicial determination in accordance with Section 89, subsection 5 of the CPC. Also, Section 134 of the CPC. That is all what we're asking. When prosecution brings a case before you, a charge sheet that is before you and a suspect before you, it is in exercise of the ODPP's power under Article 157. You had talked about it. And as I had said earlier, this power must not be abused. Indeed, and Mr. Whitty knows this very well, that what sub-article 11 says is that power of the DPP in exercising the powers conferred under this article, the DPP shall have regard to the public interest, the interest of the administration of justice, and the need to prevent and avoid abuse of the legal process. So, when a charge sheet is brought before you, that is clearly an abuse of the process, Your Honor, that is a charge that you should reject, and the court gives you, the law gives you that power. Lastly, our learned senior, who is not with us today, Mr. Mungai, told us in another court setup, that there is a reason why that the new constitution, the bar on this side, the defense, the prosecution, and the bench was made to be advocates. We no longer have police officers on that side, advocates, and then there used to be district magistrate on that side. Those days. Now we have advocates. So that when materials are brought before the court, the level at which we interrogate them is not the basic level. We should present before the court and head before the court, and the court applies its mind, its legal mind, to assess a situation so that we prevent and avoid abuse of the process. Why do I say this? There was a suggestion by my learned friend that when a charge sheet is brought before you, your role is to tell the accused person plead guilty or not guilty, and then evidence will come to prove or fail to prove. That is not what the Constitution envisages. Envisaged a situation whereby all the parties would have some basic meeting of mind as advocates, that indeed this charge sheet, we may fail in evidence, and this one is also in the decision to charge guidelines. We may not attain 100%, but there's some reasonable. The charge sheet is in the direction of something that we can prove. So you're being told, yes, there's nothing threatening, there's nothing insulting, there's nothing offensive, but nonetheless, let her take plea. We will move along and see what we will do along the way.
I hope we didn't say that. I hope the record will help us.
Let's move. We'll learn where we find ourselves. Decline that invitation and find that this is not a proper charge that the person should take. I invite my
Thank you. Your Honor, I will be brief. And I will start by quoting Justice Odunga in Republic versus Director of Public Prosecutions and another, Spate Chamanlal Kamani, whereby Justice Odunga said this: the seat of justice is a hallowed place and ought to be preserved for those matters in which the protagonists have a conviction and stand a chance of seeing the light of day. And he adds and says that a trial is neither a showbiz nor a catwalk. Why am I saying this, Your Honor? The DPP under Article 157 has the prerogative to charge. Then again, it's not for sport. It must be exercised reasonably, lawfully, and within the constitutional bounds. Your Honor, the DPP, the office of the DPP, is assumed to be sane and rational. we operate on the gracious presumption that the office of the DPP is sane. But the prerogative to charge, Your Honor, isn't a license to experiment. Short, Your Honor, we are telling you that you don't need to taste the meal to know that something is off. Even the smell of it can tell you that there is something that is off. Finally, Your Honor, two issues. We are not asking the court to test the evidence. What we are inviting the court to do is to test the lawfulness and the sufficiency of the charges. Simple. A criminal trial is only justified where there is a properly framed charge that discloses an offense in law. So we are not saying that we should call witnesses right now. All we are saying is that the DPP has that burden of telling us that these charges are lawful and within the bounds of the Constitution. Secondly, Your Honor, a trial is not a fishing expedition. The charge must disclose a known offense with clear particulars and connect the accused's conduct to that offense from the get-go. If it fails these basic tests, then the charge collapses on its own weight. Finally, under Article 52B, an accused person must be informed of the charges with sufficient detail. So, what we are saying is that the accused person ought to have known how her words amounted to offensive conduct under Section 94, which is not the case. If the DPP can't say that now, then the court has every right to stop the process. In short and in conclusion, we are not challenging the evidence. What we are challenging is the charge's existence as a valid document. If they insist on going to trial without a valid charge, that's like building a house without foundation. Circumstances, submit that charge is defective, and this person should be admitted to a personal recognizance. Yes. And they have conceded to that, to her being released.
Her personal vote.
I just wanted to mention an authority. I give the citation? Yes. Your Honor, the decision I'm talking about is the Supreme Court decision. The bench comprising of Maraga, CJ, Ibrahim, Ivan, Manjala, and Yoki. And the case is Hussein with a double S, Hussein Khalid with a KH, and 16 others versus the Attorney General and 2 others. Citation is petition number 21 of 2017. And without making the arguments in respect of this court powers to enforce fundamental rights. So I'll refer the court to paragraph 118. Allow me to just paragraph 118. The law then, the Magistrates Court Act number 26 of 2015 has since been enacted. 69(1)(a) and 2 of the Constitution to confer jurisdiction and for connected purposes. Section 8 vests jurisdiction in the Magistrate Court to hear and determine applications for enforcement of torture and cruel, inhuman, or degrading treatment or punishment, and freedom from slavery as guaranteed in Article 25A and B of the Constitution. The jurisdiction of the magistrate court does not also extend to determination of claims for compensation for loss or damage suffered in consequence of a violation, infringement, denial, or a right or fundamental freedom in the Bill of Rights. 120. We therefore find and hold that there is now legislation that provides on how magistrate courts may determine allegations of infringement of fundamental rights. Though limited, the same is constitutional as an aggrieved person, while he might not on all allegations approach the magistrate court, still has recourse to the High Court, which is the court constitutionally empowered to address allegations or violations of the right.
Yeah, but just to distinguish it, on one point, and I agree we are bound by the decision of the Supreme Court, but will you not, in a very few minutes to come, enforce Article 49? We must. I may be seated where you are seated very soon.
Yeah, that's agreeable. The court can determine whatever terms and conditions.
So to that end, I think I'm alive with the provisions of Article 49 to the Constitution. So to give effect to that, I'll release the accused person for personal bond for 50,000. So the accused person will release the personal bond for 50,000, pending the determination of the application that we just. Next week, I'm swamped with so many matters, and I'll be sitting when it's usually I put my rulings within 2 days. But unfortunately, next week I'm not, so I'll do the other week, the week after next week. Fast. So that when I finish 29. So I'm proposing if 29 is convenient, we can come back on 29 at 9 if it's convenient.
Could we do it on first now that the accused will be out on board?
Yes,
on first, yes.
Yeah,
not convenient.
Yes, and we would request an hour like 10 or 11 so that you have done the other.
So let's first of all, I feel the day.
Yeah, first is okay.
Then the week after. Convenient. We come the week after.
Surprise.
First Friday, but it's not convenient. Can we come the week after?
I think we have to propose 11th of August. You know, we have a...
It's okay, you can come.
Yeah.
I would request because in the absence of my lead counsel, I should assume I've taken the role to lead the team, and I would request a more convenient day because fourth and fifth I'm in a very complex issue. Yes, I would. I'm ready to propose 6th August. Yes.
Yes, that's good.
We are away in Shakahola.
Oh.
There is a proposal that appears to carry weight on our side, my lord. The 11th. There is a date that appears to be more convenient to every council.
Then let's go back. Let's go back to the 29th. Yeah. We could go back to the 29th if it was convenient to them. Yeah. My colleagues will represent 29.
So if 29 is okay,
yeah, it's okay. 29 is okay. Yes.
Prosecution.
We also agreeing that you give us time indication, and we are preferring another hour other than 9. Let's say 11.
11 is fine.
So we have councils have cited some authorities. If you be kind enough to state so that I get a different authority than the one you like.
We can find it with you. What I'm reminding them is that whatever they give to they pass to the court, they should give us so that if there is something very completely comparing, we could put in a comment. Yes.
Promise you will also serve.
So I think just explain those.
I think because of my years of practice, I've not met in this where counsel says I have to give the undertaking before the court. When I'm already telling you we'll exchange.
Your it was on a light note. I just said that counsel should also say he will give us.
Yeah.
I didn't mean harm.
Yeah.
Colleagues are very combative. Senior, I'm sorry, I didn't disrespect you.
Oh, yeah.
Most of life. Hey, leo mmekuja hiyo sana.
Leo tumekuvamia.
Bwana, I'll stop being friends with you. When you see your people, you start being hard on me. That was a good one.
Akiwe ngao na mlinzi, na tukae na undugu, amani na uhuru, raha tupate na ustawi. One time.
Lego, wataka uweithia nie tu. Ora mwega. Eketeke atri.
Lego, you congratulations. You know my history in the matter. But you know my history. Good job.
Tunaweza pata
Kwani nimesikia akisema mtolewa na bond.
Huyu super ameandika Musyoka. Sasa unatapitia huko nyuma. Chunge tu hii, si lazima tuishike. Just watch it.
KTN amepost status yake hapo huko.
Doi yangu. Ingia hapo. Yeah. Lazima unaona.
Chaki. Mimi unajua ni kwenda naenda.
Unataka kwenda? So unataka aje? Unataka aje? Utarekodi press.
Mimi sitarekodaje niende.
Check. Unaenda?
Narudi wapi?
Nadai videos.
Sawa, acha niende. Kuna yenye umerekodi?
Kuna yenye nimerekodi.
Sawa.
Nadai ya judge.
Sawa, haina shida.
Ya magistrate. Bro.
Sasa nimekumbuka kumbe. Kaje young man. Niliambiwa na nani?
Mimi kidogo. Mimi sijakuwa
Nani?
So I was
okay.
1-2 Kenya 1-2. Tuko live. So ladies and gentlemen, we've been here on the issues around Jane Kihara, who was unfortunately arrested yesterday. But the charges, we are surprised that the charges that were brought here by the ODPP cannot even hold water. They could not substantiate what they are saying. So Mheshimiwa has been released on a bond of 50,000. But what we are asking, our main concern is why would the government take time to frustrate leaders and make the country look like it's a joke? Because we cannot have members of parliament being harassed in this way and charges that do not hold water. The other day we saw young people, a group of young leaders and youths being charged with terrorism. We cannot operate this way. We are putting our country in a very bad light internationally. And the president and the Kenya regime should come back to their senses and run this nation according to the constitution in respect to the law. My name is Ken Babu. Ahadi Kenya.
My name is Nick Mwangi, the SG Kenya Ahadi Party. Well, you know, I'm telling many Kenyans, they came for the young people, now they have come for our parents. We are not safe. And that's why we are saying this government has to go. Today, with my friend Ken Babu, because we are in the united opposition, we have come here to support Mheshimiwa Jane Kihara. And all these parties, Kenya Ahadi Party, Wiper, DCP, DAP, are singing one song. One time is real, Kasongo anaenda nyumbani.
Natural death. Ile siku ya judgment, that judge, I'm not support the part of all evidence. This guy anakuja tu hivi bili yote hizi anasema wakili kusubmit na akasema sana hata kama ni unarudisha blame. Wakila vijana nani?
Nakwambia wanangojea nini? Simungesonga tu kidogo hivi mkusalimiane karibu karibu. Hata mimi.
Hiyo simu napiga nitoe watu wapiga nitoe. Hata that point siwezi jiwende hata wadogo wanatoa. Ile siku naona ngira anasema I think there is need. I think there is need. There's an urgent need for dialogue. Iwe maana ametoka. Imelishwa mikopo.
Amechukuaje muda kutoka ama alikuwa shatoka na tuji? Hapa.
Hey. Hapa.
Shika hivi.
Namna gani? Mlikataa kututetea yetu ya mishahara tukufe. Mnaleta ya pope.
Sio hiyo. Tunatuma ya hiyo. Itaandika. Basi ngoja kama atuongee. Nimeweka na hiyo kwa moto. Acha kuwekea mic.
Yes. Haya. Sawa. Nianze. Mimi kwa majina naitwa Mheshimiwa Karanja, mimi ni MCA wa Naivasha East, bali Mheshimiwa Jane anatoka. Leo tulikuwa tumekuja hapa kwa sababu Mheshimiwa alikamatwa jana, na kwa hivyo tukakuja hapa kumpatia moral support. Lakini ile mambo imenistua, kuna mambo kadhaa ambayo tumestuka kwa sababu tumesikia kesi na wale watu wa historia kama sisi, na tumeona ya kwamba there is a problem. Jambo la kwanza, Mheshimiwa, hii serikali kama watu hawajui ilivomiwa kwake. President Ruto walikuwa wanakuja kwake Maraigushu na walikuwa wanakuja hapa Nairobi. Kwa hivyo hii serikali yule aliform ni Mheshimiwa Jane. Number 2, ile mambo ambayo tumesikia ambayo anatafutwa nayo tukaona kama hakuna. Kwa hivyo sisi tunauliza serikali, number 1, miaka ya Mheshimiwa Jane Kihara si ya kuwekwa kwa Subaru, si ya kuhangaishwa kana kwamba yeye hajui Nairobi. Yeye amepita hicho kiwango. Hata yeye miaka yake ni senior citizen. We should be respecting our mothers. We should not come ati hapa na kuaibisha. In actual sense vile nimeona ni kana kwamba ni serikali inajiaibisha kwa kuleta mama yao kwa kesi. So hiyo nikaona ya kwamba there is a big problem morally, kuna shida. Number 2, tuambie serikali ya kwamba mtu akiongea kwa siasa, ng'ang'aneni na yeye kisiasa, si kwa koti. Why is politicians calling judiciary to assist where they have been unable to prove? So mambo ambayo yamesemwa kisiasa huko, usije useme kisiasa, ujibu kisiasa. Kwa hivyo hiyo tumeonelea hivyo. Na mwisho, sababu sitaki kusema sana ili mheshimiwa aje aseme, tunasema hivi ya kwamba sisi kama watu wa Naivasha na sisi kama mbunge wetu, let mbunge wetu afanye kazi ambayo alichaguliwa na watu. Afanye nini? Afanye hii mambo nyingine hii sinani ganza, hatutaki. Na kama Ishongo alisema baba yao na mama yao wa 105 years alitumiwa serikali imuprotect. Kwa nini Jane ambaye pia ni senior citizen amutumi serikali iprotect yeye, mnatuma yeye akuje kwa mahakama? Huyo Jane hajawahi kuwa kwa mahakama, hajawahi letwa. Sasa mnamleta, mnamweka, mnamuaibisha, na ni yeye aliform serikali. Kama serikali haitaki laana ya nyanya mzee miaka 70, kama serikali haitaki laana, iendelee na hii kesi. Ikiendelea na hii kesi, nakwambia ile laana itapatikana hapa Kenya haujawahi ipata. Wacha mama ambaye ni mjane afanye kazi yake ambayo aliteuli, na kama wao wanataka wawe na wajane, hii kesi itawaletea wajane. Wanako. Tazama kitu. Wanako yuko hapa. Unaita chugia.
What can you say about the same, sir?
Mimi vile nitasema, kwanza mimi nimetoka Naivasha na nilichagua mheshimiwa Jane, na Jane tunamjua kama mama mwema ambaye hana mambo mengi. Kuhusu hii kesi tunasema kama serikali imekaa chini kufikiria kuangaisha MPs wale wako na misimamo mikali, basi watafanya kazi gumu, sababu hata tukitoka hapa bado tunaenda na ile misimamo mikali. Mimi ragula lile ninauliza sana ni kwa nini serikali ikatuma Subaru 14 siende sikashike mwanamke mmoja na walikuwa wanaume tupu. Tangu lini mwanamke mmoja akashikwa na wanaume zaidi ya 30? Who is Jane kutumiwa wanaume zaidi ya 30 kumshika? Kweli sheria imekubalia mwanamke aende akashikwa na wanaume? Huko walikuwa namuweka kwa Subaru wampeleke, walikuwa nampeleka wapi? Hii tunakemea na tunakataa kabisa. Kama ni mwanamke atumiwe wanawake wamkamate, lakini sio wanaume.
Thank you. Wakiendelea hivi ni kama hata one time haitaisha. Wakiendelea hivi hivi
Mimi naitwa
mniambie, you are ready?
Mimi naitwa Steve Kanyanya kutoka Meru. Constituency inaitwa Buri. Na niko hapa kwa sababu ya solidarity. Nilikuwa nataka kukuja kuconfirm ni ukweli walishika huyu mama kumsumbua tu bure. Na hii tabia wakiendelea nayo, acha hivyo wanaambiwa one time. Hata sioni hii tamu ikiisha kwa sababu ya hii ujinga na upuzi mwingi wenye iko na hii serikali. Sasa mmetoka kupiga watu marizazi miguu, mmetoka kuwaua, sasa mmeanza kushika hata watu hata hawana jinda, hawana stress, alafu mnakuja kutuambia hapa mko kwa serikali. Ondeni kabisa na hii serikali yenu mpeleke huko.
Thank you so much. Baje mwenzako. Baje wapi?
Yes, mimi naitwa Erastus Mwariri kutoka maeneo ya Naivasha Karagita. Ni huzuni kubwa sana ambapo tumeiona kuanzia siku ya jana kwamba magari mengi sana yalikimbia na mafuta yetu kama wananchi. Mafuta yetu kama wananchi, resources ambazo, taxes ambazo tunatoa ndizo zilitumika kwa wingi sana kwa magari mengi kuwekwa mafuta kuendea mama mmoja. Hilo jambo limenikera sana kama mimi mkaaji wa Karakta maeneo ya Hell's Gate. Kwa hivyo hilo jambo nalikemea sana kwa sababu walikuja bila hata wangetuma tu mwanamke amuendee tu mwanamke mwenzake, lakini walienda wanaume na matia gas na Land Cruiser na nini. Na hilo jambo limetukera kabisa sisi wakaaji wa Naivasha. Kwa hivyo bila wasiwasi sisi tunasema ni tamu moja. Kama hiyo ndio jambo, hakuna shida, sisi ni tamu moja. Na kama kusema tamu moja ni shida, si hata wenye wanasema tamu mbili si wanakosea wenye wanasema tamu moja. Kwa hivyo hili jambo basi tunafaa kubalance. Wenye wanasema tamu moja waheshimiwe, wenye wanasema tamu mbili waheshimiwe. Sisi kama wakaaji wa Naivasha, kama tamu moja ndio inaleta shida, wacha itulete shida tu. Asanteni.
Yes. Unaitwa nani?
Mimi naitwa Grace Mumanyi from Nakuru, coordinator DCP party. What I would say is that it is bad that Kenya is a democratic country and everyone has freedom to express his or her views in this country. But now it has come a time when the sitting government is on those people who are in opposition, those people of one term, those people who are saying Kasongo must go. But what I want to say today, as we are here in the low courts of Nairobi because of Honorable Jane Kihara, is that this narrative has already sunk in Kenyans. And there is no way that this government is going to go for more than one term. Regardless of the intimidations, regardless of the witch hunting, it is clear it is written on the wall that this government is one term. What I know is that it has come to dawn to this government that they are on their toes, they are living. We are voting them out. So they want to sell fear to Kenyans and especially to women leaders, thinking that they are going to shy off, they are going to relent, and they are going to be silent. But I want to say that women leaders of this country, we are not going to be silenced of anything. Actually, the moves that we are taking, speaking loudly, talking and expressing our views, is an urge from within because of the many tribulations that as Kenyans we have come through. Even when you find the Gen Z doing what they are doing, it is because that they are pushed by problems and they are pushed by poor governance of this country. So we are not going to stop. As women leaders, we shall continue to condemn what the government is doing, to abduct, to witch hunt, to summon, to DCIs, even to the courts at this level. We are just going to orient ourselves with these scenarios, because between now and 2027, I know there are going to be many, but women of this country, we are not keeping quiet. We are going to speak very loudly.
Even the public is complaining much about the executive. Is the judicial surprised? Is it running its services?
I want to believe that even the judiciary, any other department of this country is fed up. They are human beings, they are Kenyans, they are Kenyan citizens, and everybody is tired. Even the police sector, everyone. So it is not that the judiciary, we can say that they are biased or they are not, but they are also concerned that at the end of the day, our country is just about to go to the dogs, and it is not going to happen as they watch. Everyone is concerned.
I'm telling you,
I want to say that the court proceedings were very fair, because according to the accusations, there was any tangible evidence that Honorable Kihara has committed any offense. It was just speculations, allegations, and more so, there was nothing tangible that she can be accused of. It was just propagandas and intimidations. And that is why the court has said she's out on that board of 50K, and then ruling will be done later. But we want to thank the judiciary that the ruling was fair, because us as Kenyan citizens all over in Kenya and even in diaspora who followed this matter, it could not hold any sense at all. Yeah, as I conclude, I would tell Kenyans, wherever they are, you are listening to me, let us not be intimidated, let us not keep quiet, let us continue raising our voices, let us continue crying for freedom, and I want to assure Kenyans that it is coming tomorrow. Thank you. Thank you.
Umesema niseme jambo. Hapo iko sawa? Thank you very much. My good name is Tony Bidi. I'm here in solidarity with Mheshimiwa Jane Kihara, who is being intimidated by the state because of our political stance. And what we are saying, this do not come as a surprise. We are expecting, and we are also expecting more people to be arrested. But the good thing is that we have impartial judiciary ambayo inasimama na wananchi. we have, in the recent past, we've witnessed the increasingly pattern of state intolerance of dissent and intimidations against voices that challenge the status quo. What we are saying is that the people of Kenya are done and they are not ready to be intimidated anymore. No one is willing to listen to a government that is killing its own people. No one is ready to negotiate with a government that is killing its people. And all this intimidation cannot stop the narrative that has built up on one term. Sasa tunasema the constant bado ni one term. Watushike leo, watuachilie kesho, watushike. Itakuwa capture and recapture and arrest and the arrest, but we are ready for that going into the future. These are the form of intimidation that we are talking about. In fact, this government has suspended the rights of an arrested person. They are no longer following the procedures for arresting individuals. So this, what I'm saying in simple terms is that the rights of arrested persons have been fully suspended. They are no longer existing in this government. And we are not expecting them to do better in the remaining time, because they only have about 2 years and then we reclaim back our country. Yeah.
What can you tell Kenyans about the issue? Maybe you want to need.
What I want to tell Kenya is that they should not relent, even in the face of persecutions. Let us stand firm. Let us stand united. Let us stand with those people that are challenging the status quo. Whenever they are arrested, let's raise our voices out, so that, because we've seen a pattern whereby when people are arrested, they end up disappearing completely. They are held incommunicado. In fact, we don't call that arrest. That's an abduction. So whenever any Kenyan of sound mind is arrested, any Kenyan that is challenging the status quo is arrested, let us stand in solidarity with them. Because as we speak today, no one is safe. As long as you are challenging the status quo, you are not safe. Today is someone else, tomorrow it might be you. So let's stand in solidarity with each other. Thank you very much.
Lete mheshimiwa mmoja hapa.
Aje? Sawa. Acha basi usikuja hapo unishutingi kitu hapo hivyo.
Record.
Ya record. Unaenda tu hivi unachukua kamera zote.
Yes, hello sir. Unaitwa nani?
Mimi naitwa Bishop Shikshik, nasimama kiti cha MCA pale Zimmerman, na siku ya leo tuko hapa Milimani High Court. Yeah.
Leta hii.
Microphone utawapea hapo mbele.
Sawa, tutafanya.
Okay.
One step back.
Kibo yako imekwama. Kibo yako umekanyanga.
Just for talking purposes.
Oh.
When you're done, kazi.
Thank you so much, members of the Fourth Estate. We wish to thank you for the support you've been giving to us. We are greatly humbled by this opportunity and this apparatus that you always afford them to us. We don't take it for granted that you're part and parcel of the processes that are taking part in this country. And had it not been for you, the world would never get to know what is happening in this country. Today we were in court and they brought charges against Mheshimiwa Jane Kihara, the Member of Parliament for Naivasha. The charges was those of incitement, that she incited and stated that on the 7th, Sabasaba Day, the state, through its operators, which were mentioned in the charge sheet, namely the National Youth Service, was used, or their facilities in terms of transport, buses were used to transport goons who have been causing mayhem and chaos and causing destruction to people's properties. And that the statement might not have been taken in kind by Mr. William Ruto. Those are the reasons that are the basis upon which she was charged. But we have nevertheless objected to the charges, and the magistrate has taken in our submissions, and we will be coming back on the 29th of July for a ruling. We also want to thank the parties who have been with us, His Excellency Kalonzo Musyoka, His Excellency Rigathi Gachagua, Her Excellency Martha Karua, Justin Muturi, for the support that you've been giving to us through these processes. With me, I'm with members of Parliament. We've also been very supportive to our processes. Some were with us late in the night, and others are with us today. Maybe with your permission, we can have an address from the Member of Parliament, Mr. Kagusha.
Yeah, thank you very much. Today we are here at the law courts, unfortunately, once again to deal with issues that we perceive to be issues of abuse of power. If you look at the charge sheet that has been brought before the magistrate this morning, you realize that it captures the issues that were raised in a press conference at Pan-Africa Hotel on the 8th of July. That press conference that was done there was done by the members of Parliament and also members of the opposition. And in that press conference, very many people did give details about exactly what was happening on 7th. And what the members did ask is that the government must conduct a proper investigation. Of course, we also pointed out what we thought really happened on 7th, and indeed what we believe to have happened until today. Unfortunately, Honorable Jane Kihara has been picked as having incited the people into violence. This happened after the 7th. And so one of the questions that one wonders, whom did Jane Kihara incite into violence? That is not anywhere in the charge sheet that has been brought before the court today. And of course, the other issue that you notice is that the DPP has absolutely abused his powers with his office, the office of the DPP, And that is why today, if you look at the way they are handling this thing in a very clandestine manner and lackluster manner in the court, you realize it's like they're doing it as a joke. It's just some kind of a play that they are having. And of course, we understand what the decision that has been made is that all the people who are critical of the government decisions are going to be taken on, and charged so that they can be kept busy. And so one of the things you are likely to see, and we know and believe that is what they are doing, is to try and charge all the members of parliament who are affiliated to Rigathi Gachagua and the two opposition, so that we can be kept busy with court processes, and so that we are not critical and we are not talking on behalf and for Kenyans. And I want to say that is something that has we know very well, and it is not something that is going to work. The more intimidated we are, or the more the intimidators, the more stronger we become. We are going to stand for Kenyans, we are going to start with Kenyans, and we are not going to allow any one of us to be intimidated to the point where they are going to be silenced. So if they are looking for silence, that is not one thing that they are going to get from us. We are going to follow the law in whatever we are doing and ensure that whatever we are pushing for, the rights of every Kenyan, we are pushing for corruption to cease in this country. We are definitely pushing for government to respect human rights. That is not something that we are about to back down on. We will do it more and more, and we will keep very strong. And we want to ask the government to concentrate on fighting Al-Shabaab. We know very well as we are talking now, we have people who are being killed. Our KDF is being killed by Al-Shabaab. The security apparatus are supposed to be focused on protecting Kenyans, but not fighting Kenyans. We have seen politicians who have said extremely remarkable points, especially when it comes to the issue of violence. We have seen politicians who have done hate speech. We had a member of parliament who actually talked about bringing Pokot boys in town to come and fight protesters. We have had members of parliament who have asked the government to shoot people and kill them. But until today, there is no action taken against them. But for Jane Kihara, who did a presser, she is now being hunted like a swara, being hunted like a criminal. And yet we know this gracious lady here is a very respectable lady and has never been in the wrong part of the law. We condemn this with the strongest term possible.
Thank you very much, members of the fourth estate. Honorable Jane Kihara has never been arrested before. She was arrested yesterday. And I want to tell the people of Kenya, the people of Naivasha, and those who believe in one term, now the fear is gone. You know what she was afraid, how they look like the cells, the fear is gone. So that means we will continue with fighting for our people. I know the members of parliament from Mount Kenya, those who did a press briefing the other day, purporting to speak on behalf of the people of Mount Kenya, are the one who gave a green light. And I believe even for us, they will come for us, and we are ready. But I want to remind them that we will not be silenced, we will not keep quiet, we will talk about the ills of this government, the ills of this regime. We will tell Kasongo one term, we will say it whenever we are, even if they bury us, we'll be able to lift one hand and point to the skies saying one term. But I want to urge the members of parliament who are dining with Kasongo, who are giving these press briefings so that they can profile us, those who are fighting for the people. I want to remind them to be like Esther in the Bible. Esther was a Jew. When Esther heard the king and the people around the king have said, kill all the Jews, Esther remembered she is a Jew and went to the king and told the king, if you kill all the Jews, I'm your wife, I'll be killed too. So I'm telling them, if you hear those around the president perpetrating or coming up with all this plan against your own people, be like Esther. Go tell them, please, when you do this to our people, it will be us who will be next. So it is a Bible verse, so go read it and read it very well. But what we are saying is that we are not going to be cowed. We'll go on with our meetings. We will go on within Mount Kenya and out Mount Kenya so that we can tell our people this government that we voted for is the one that has decided to crucify the honorable members on those people who believe in liberating this nation. And you can see the pattern. Started with Koimbori. Now we are in Jane Kihara. We have gone to Mukunji. And we are ready even for us. They will come. But what we are saying, and we are telling the judiciary, please follow the rule of law. Do not be intimidated. Because they came for Gen Zs, we did nothing because we are not Gen Zs. They have come now for the leaders. Probably some people are not doing anything because they are not leaders. Now when they come for the judiciary, who will be there to fight for the judiciary? So we are telling judiciary, let's follow the law, and we thank the judiciary today because they have listened and they have given us an opportunity to defend and to say what is supposed to be said when it comes to matters of small issues and small cases that was brought before the court to say that Honorable Jane Kihara has broken the law. Which law? It is freedom of expression. And if at all whatever they are saying, she has broken the law, if you look at those words that she has said, if at all she said them, compare with what Ruto himself is saying. Enough is enough. Nimewazoea. Sijui nimefanya nini. Look at those words and James and see who is supposed to be on this court of law. Those are the things that we are saying today.
Kwanza ni kushukuru kwamba mahakama yameweza kumwachilia Mheshimiwa Jane Kihara. Lakini ile inatushtua zaidi, kiongozi wa walio wengi Kimani Ichung'wah alitaja kwa bunge watu kiasi fulani wa bunge kiwemo Jane Kihara, Mukunji, na vile yale majina aliyotaja kwa bunge, hao wajumbe wameanza kukamatwa mmoja mmoja. Na mimi nauliza idara za DCI pamoja na wale ambao wanafanya ujasusi, kwa nini vile Kimani Ichung'wah alisema ndivyo mnafanya? Mlisema Jane Kihara atashikwa, sasa Jane Kihara ameshikwa. Mukunji alikuwa ameshikwa. Na tunajua mko na orodha. Lakini haya yote ambayo mnafanya, hakuna ile itabadilisha uamuzi wetu wa kuweza kuendelea kukashifu yale ambayo serikali inafanya. William Ruto sio sheria. William Ruto sio Mwenyezi Mungu. Na William Ruto hata tunyamazisha wale wako na maoni tofauti. Wale tumechaguliwa kwa chama cha UDA kama Jane Kihara, kama Kagushia, tumesema yeye ni one term na ni sisi ndio tulikuwa tumemchagua. Lakini kwa sababu hatujaridhika na vile wanafanyia wa Kenya, tumesimama kusema vile anavyofanya si sawa. Lakini ya muhimu zaidi, kwa nini DCI? Kwa nini wale wanaenda kamata watu? Ile list Ichung'wah alisoma kwa bunge ndio list mnaenda kutimiza. Inamaanisha this is selective justice. Ni watu wameketi chini kuamua, wacha tuhangaishe huyu na tuhangaishe huyu. Ya mwisho rais, haina shida, wewe arrest, wewe panga vile unapanga, siku ya kiyama ni 2027 na wewe utakuwa rais wa term moja.
So thank you. Thank you members of the fourth estate. And today we are glad that the courts have chosen constitution over manipulation by the government. We are so happy that now the courts are starting to attend to these cases with the consciousness that they deserve. We've seen the way the government is abusing the justice system in this country by trying to politically persecute those people who are against it. Let us talk about this whole issue of Gen Zs and protests and everything. Let it not be lost to Kenyans that the initial protests were very peaceful. I remember one Kimani Ichung'wah saying that these are kids who've come from affluent families who arrived by Uber and eat at KFC, and it was very peaceful. It is the government of the day under William Kasongo Ruto who invited goons to come and disrupt these protests. And after that, he started calling our youth goons, and he's been trying to kill them in the pretext that he's going to protect public property. It cannot be lost to Kenyans. It is Ruto who invited goons to come and try and manipulate the whole process of protest in Nairobi. And now that he's purporting to issue orders about shooting people in the leg, tumesikia Nelson Koech akisema watu wapigwe risasi wakufe. Toka wale watu wote wamekufa, wameua goons wangapi? Sisi tunajua waliua kijana wa mask, wameua mtoto Dumberi, wameua mtu mwingine alikuwa idol. Hakuna hata sura ya guni yote tumeona amepigwa risasi. Kwa hivyo hii ni mambo yao, na sisi nasema hawatatutisha. No amount of intimidation itatutisha. Hii nchi ni yetu. Si Kasongo alitupea visa ya kuja hapa, na yeye pia atakufa. ataenda huko, atakaa kwa shetani. We don't care. So kila mtu akona moyo moja, na acha kutisha mama yetu hapa hivi. Watu wanaongea vibaya, akina Kamketo wanasema wataleta guns Nairobi. Hiyo ni statement tosha yenye mtu anafaa kushikwa na afungwa maisha. Lakini wanakuja kutafutia makesi zenye haziko, lakini kila kitu ni kwa muda. And we are ready for them. We must speak out because one day future generations utauliza, Kasongo akipeleka hii nchi hadi hapa mlifanya nini? Sisi kazi yetu ni kuongea na tutaongea hadi atoke. Na ile siku yenye mimi nitafurahi sana ni ile siku gazeti mtaandika former president William Ruto, hiyo tu nikisoma hapo ndio nitafurahi. Asante.
Wacha tu have mama ongea kidogo, just one minute, then we shall have one Gen Z.
Kwanza nikushukuru mawakili wakiongozwa na His Excellency Kalonzo Musyoka, na nipongeze supporters wale walikuja hapa kotini na wale wanatufuata, na kwa social media nimeona a lot of support. Na kwa vile mmesikia hii kesi haijaisha, sitaweza kuongea mambo ya kesi kwa sababu mawakili wameongea, sitaki wanifuate tena. Lakini nimefika climax of my politics. Kulala cell. Mimi sijalala cell. Hata to be booked kwa OB, I've never been booked. So nimefika climax. Kwa hivyo mtu akifikiria ataninyamazisha ajue amesahau. Tena niambie President Ruto, with Ishongwa as your friend, you don't need any other enemy. With Ishongwa around you, you need no other enemy. Kwa sababu huyo ndiye anakosea wa Kenya. Najua alinitusi, akaniambia ni behave my age. My age ni hii. To fight for Kenyans, to fight for my people. Hata kama ningewekwa cell wiki mzima, I am prepared. Mimi sizai, kazi yangu ni kupigania. Najua hawa ni wangwana, hawa ni wadogo, wako na watoto wanalea. Hawa ni watoto wangu. If it means kukaa cell na sisi tupate haki yetu, hiyo ndivyo. Lakini mambo ya case, nishukuru the battery of lawyers who came. Nishukuru my supporters, na niambie Kenyans, we have to keep fighting because our country is going to the dogs.
One time.
Haya. Sawa. Thank you so much, guys, for choosing Kenya News Alert TV, and we really appreciate. Here is Milimani Law Court, na hivyo ndio mambo yamekuwa. Let's meet maybe again when the case is going to be heard next time. Thank you so much. May we hook up later. Goodbye.